doing further teaching, of people in their areas. And that's how our system of education in the fire service is largely orchestrated. Obviously, the states and locales are doing their things as well, but it actually starts from a national organization and moves down through that and works at all levels of government like things do in the fire service. So, I mean, one can look at what materials they were using, and as my report indicates, that for most of this period, their curricula are basically following Kirk's. And they have supplementary material and other ways of talking about it and what have you. So obviously, I think that's an important point in terms of understanding where the community is at, because that's the leadership position in all this, and brings together some form of consensus nationally as to how this enterprise of educating fire investigators need to be going. You notice also that I shy away relatively from saying anything about how definitive the standard of care was on any particular fire indicator, because that was all over the place. And I think in that particular issue, you can't read books or look at how courses have been taught and come to a clear conclusion that everybody agreed on that. You can agree on the fact that there's plenty of warnings that many of those indicators aren't reliable. Warnings, as in, don't rely on this solely kind of information. And our investigators that in these cases acknowledge those that they were not regarded at the time as being uniquely indicative of use of large quantities of accelerant, for instance. So when the investigators themselves and this broader literature, were in general agreement about something, that sounds like a standard of care to me. Obviously, any of those determinations with the lack of a consensus document is subject to judgments. And I made my judgments. And obviously, it's your job, I presume, to make your judgments and use mine simply as a guide to where you may go with that. Some things haven't changed that much. I mean, as I indicated, how eyewitness interviewing and stuff. I mean, it may be better codified in some sense, but the role of interviewing in fire investigations, has been and will continue to be, an important and valued element.
I guess I'm not hearing a very clear answer to Lance's question. Mm-hmm. I think pretty uniformly within the commission, in reading your report, commissioners did identify the contradiction that Lance was talking about. You state pretty clearly that there was not a standard of care, and we've used different phrases, standard of practice, we're all talking about the same thing. There was not a standard of practice for fire investigation, particularly in Texas during the time period of this investigation, that was identifiable. And by that, I'm assuming you're using generically the whole investigative process. You certainly identified that there may have been specific parts of an investigation that were more finely tuned than others, but in general, there was not a standard of practice. And yet, later on in your report and in your executive summary, even more clearly, you contradict that by saying that they violated a standard of practice.
Okay.
I'm very much interested in a clear answer to Lance's question.
Yes. Thank you for that. We all can easily agree that a codified, written, standard of care, single document, 921 style did not exist at the time. Okay? The broad brush. There isn't a single document that says what everybody thought they should be doing, what all the teachers thought they should be teaching. Stipulate. That didn't exist. We're clear about that.
Yeah, I think that's uniform with the other opinions that we got as well.
So, does that mean that a standard does not exist? No. I mean, there are elements of what people did that everybody agreed on, whether they bothered to sit in a room together and come to some consensus as to where it was and then write it down.
And that's what you're referring to when you talk about this national research that you did.
Well, the research, it's national in scope to the extent the textbooks are certainly not local, yes.
Did you do any research to identify what the Texas, a state standard of practice was?
I did not identify anything that I didn't come to Texas and do research here, I will say, but I haven't identified anything that indicates to me that there is a varying standard of care on a national basis because of the educational system that has been in place.
But it would be fair to say then that you did not specifically research anything in Texas.
With regard to standard of care in particular, that's unique to Texas. That is fair. That is entirely fair.
Some of these other individuals had more familiarity with the Texas standard of practice and came to the conclusion that even looking at that there was not a uniform standard of practice, either a written one or one that was put together by word of mouth. Do you have any reason to think that their familiarity with that Texas practice would be better than yours?
I'm not aware of the documents that you're referring to.
I think that helped clarify our question, but I appreciate it.
Give me your thoughts on national versus state standard. I mean, certainly we have to look at what fire investigators were being taught in Texas by different agencies that are in charge of training them. Do you have any opinions or thoughts on to what level or what extent the folks in charge of that training or the agencies involved in Texas should look to national standards or national materials that are available in helping to develop local standards, or do you think that they should just be totally separate? It's kind of a vague question. I just want your opinion, your thoughts on that.
There is no reason to expect that one state's standards should be different than another state's. I mean, we all aspire to do as best we can. And since the legal systems that we work in are quite similar, not identical, but quite similar, and obviously the knowledge base that we all work from is the same, and the educational resources are national, if not international in scope, I see no reason why there would be or should be a local standard of care that's distinct and different from one that would be applicable to broader jurisdictions.
But wouldn't it be fair to say that we've come to a consensus on that opinion much more in the more modern fire investigator view than perhaps in the late 1980s, early 1990s?
The process of initiating the development of NFPA 921 has been of great value to the fire investigation community. It has pulled together in a single room dozens of people who are experts in that field, brought input from far more people, brought a level of consensus that's not readily achievable in any other way. Individual book authors obviously are familiar with all of the information that's out there as best that they can individually do that. And they, in their teaching and writing, are attempting to, reflect, the broadest and best enunciation of the fire investigation art and science. But clearly NFPA 921, getting people in a room, putting a document on the street, getting comments, proposals through a public process, has been invaluable to the community.
Going back to the original question about the lack of existence of a uniform standard and your comments that even though no such uniform standard existed,
Is documented in a single place, yes.
at the time, yet you still found some real issues with that. Maybe it would be instructive for you to give us a couple of examples of things that you uncovered in your report that caused you to come to that conclusion. If there are major ones that stick out in your mind? I guess just by way of example, and kind of following up on what Mr. Bradley was asking you about.
Well, I mean, in my view, the most important ones I've tried to touch on. The overall methodology of, if you're going to call this arson, you have to eliminate all accidental and natural causes. That is something that I believe is a standard. It's not a documented standard, but it is our common understanding among educators and practitioners that that is how you make a determination that arson has occurred. You have to eliminate all accidental and natural causes. That's not a new thing. The way we go about that is somewhat different in the 80s versus in the current world, i.e. scientific method versus eliminating alternate causes. But that principle is fairly timeless and accepted, I think, generally. And that, I think that's how it becomes the standard, is by developing a general consensus in the community that this is how investigations are to be done. Similarly, I mean, the use of eyewitness information. I mean, it has never been okay in fire investigation to go in, spend a couple hours on a fire scene, poke around, look around, leave, write a report, and never talk to anybody. I mean, interviewing first responders, interviewing eyewitnesses, and dealing with what they have to say has always been a part of a fire investigation and forensic investigation far more broadly than that. And that's, I mean, do you need that to be written down in 921 to understand that? Well, I think not, So, and with regard to the pattern stuff and the indicator stuff is far more difficult. It's more problematic because there are, at the time, there were people who said this pattern means this and it didn't, and other people who understood that it didn't. The consensus, the concurrence of opinions about that was developing during the 80s. And I would not have if the only things wrong with the investigations was that these investigators believed that this pattern uniquely meant something that it didn't mean at the time. If that's all that was wrong, I would not have said they violated the standard of care, because there were, at that time, sizable numbers of people who believed that these floor patterns meant it had to be accelerant-based and had to have occurred that way. They're wrong, but it was, an understanding that a sizable number of people had, and I would not, have that rise to the level of, a standard when that lack of consensus, is apparent. Now, here I see those pattern issues as a problem nonetheless, because we have investigators who acknowledged that they were not unique. Now that changes a lot. I mean, if these guys believed that this pattern means this, it can't mean anything else, we can talk about that. But when they acknowledge that they are not unique, but use them as the means to determine that this must be arson and not ruling out accidental causes, it's linked to the need to rule out accidental causes. If it's not uniquely arson-based, pattern, then there are the potential for accidental causes that can cause that pattern, and hence you don't know. And the right thing for an investigator to do under the circumstances of I have more than one cause is undetermined. I don't know. That's a legitimate finding.
The other questions that I have right in front of me, I believe, were questions that were submitted to you in advance, and I think that they were contributed by other members. And I believe that you may have touched on some or all of this in your response, but what I would do is ask those members here if they're satisfied with any written documents in response to those questions that the doctor has given us, or do you want to follow up with specific questions?
The two investigators, you acknowledge, or they acknowledge, that there were other explanations for the pattern. They knew that. Where would they have learned that?
From text.
Back to standard of care, and where would they have been able to acquire that knowledge?
They acquired that knowledge ultimately from textbooks, reference books that said, here are these kinds of patterns. They may mean this, but they may not. And how did that arise? I mean, it gives rise to an interesting question of how at the time was this knowledge developed? And it is sadly the case that in the run-up, call it up to the 80s, because obviously research takes time to get into practice, that there was no coherent research programs in forensic in pattern recognition and indicators and the general art and science of fire investigation. Most of what was known was individual investigators on an opportunistic basis having the opportunity to experiments or draw from things that they had done to come to an understanding of, ooh, I once thought this pattern meant something, and based on this training exercise, I saw that on the floor, and there was no arson. Or, actually having the opportunity to do it in a more formal scientific setting. But, I mean, the profession was bootstrapping itself at the time. It understood that it was behind. I mean, as I indicated in the paper that I provided to you more recently, it was the case that in the 70s, fire investigators were being more exposed to fire science and fire scientists because in large loss fires of both property and lives in the 70s and going into the 80s, fire scientists, fire protection engineers were being used by attorneys in lawsuits. And the investigation community were working alongside them. And they're looking over and saying, wow, look at this stuff. I should be using this. And the astute members of the investigation committee in the 70s were seeing this, and starting to read fire protection engineering books and fire science books, bringing that to their practice, bringing it to their writing, and beginning the process of integrating what was known based on fire science into the art and science of fire investigation. None of the things that we're talking about here is the actual fire science is the limiting reagent. Fire science has been ahead and known most of what we need to know to answer most of these questions long before you could say there was a standard. And it's really what has happened in the fire investigation community is a growth process in the sense of recognizing this resource of fire science that's a formal discipline that did have funding, that did have a national research focus, that was learning things based on science, that we can use that as a resource, bring it over, and build our profession in a way that will help us. That's, I would generally say that starts in the 70s. I can't say it didn't happen before that, but it certainly got legs in the 70s and proceeded from there. And so that's how up through the 80s, knowledge, with regard to indicators was developed in the fire investigation community, and it's a little bit, it's better now in the sense that there is some national funding for research in fire investigation. It's not huge. The National Research Council has, made its opinions known on the need for more in a broader sense in forensic sciences, and fire investigation certainly no exception.
So would it be safe to assume that they had been exposed at some time to the concept that the pattern may or may not reflect use of an accelerant?
Yes.
Given their conclusions and their statements and their testimony that they recognize these patterns may be caused by something else.
Yes, I think it's extremely significant that they themselves admitted that, yes.
Can you offer really your opinion, your position on the origin and spread of the fire based on your review?
Cause undetermined in both cases. In the Willis case, I have a fairly poorly developed understanding of the area of origin. Living room, dining room is the best that I can say based on what I've seen. In the Willingham case, the room of origin is the child's bedroom. Beyond that, I couldn't say. And, I think we all need to recognize that, areas of origin start large and get small as the quality information improves. And, the ability to go from undetermined to determined in terms of cause, improves as more data, is brought to bear. And we can't do any better than the data that was collected on the day.
Dr. Violet, having reviewed the documents, what evidence do you find that would support a fire investigator at the time reaching a conclusion that this fire was arson? And would that opinion have been the same in 1991 and also in 2004 when the fire was, the documents were re-examined by other experts?
I'm going to ask you to restate the question. I'm sorry.
So based on the documents that you've reviewed to date on the Willingham case,
On the Willingham, okay.
on the Willingham case, what evidence is there to support a finding of arson by a fire investigator in 1991?
What evidence do we have, did they have then, and that they could have recognized, or that we can recognize now, that points to arson as the cause of the fire?
Would you support their conclusion based on information that was available in 1991?
No, based on what was available at the time, this is an undetermined, the cause is undetermined. There's no way that you were going to determine a cause based on what they knew at the time. There's no way.
And by undetermined, you're not excluding arson.
Well, no, I mean undetermined. I mean I mean it like I mean it, yes.
Well, I say that because the media sometimes takes that answer and turns it into there was not arson. And would it be inaccurate for the media to report that your conclusion is that there was no arson?
You are correct. I have not come to the conclusion that neither of these fires were or could have been arson.
But my question is, would it be incorrect for the media to report it that way?
Yes.
You have not said that.
No, I haven't said that.
So just to clarify then, as time went on, as fire science developed, as standards of practice improved over the years, would I be correct in assuming then that later on, after 1991, you'd have the same opinion that there still wouldn't be sufficient evidence to corroborate a finding of arson? It would still be undetermined?
I mean, it's even more strongly the case as time moves along.
Right, I just wanted to clarify.
Right, yeah. There's no question that as time moves along, the support for the determination that these were arson fires gets less and less, not more and more.
Well, that may or may not be true. There can be new information that could cause you to conclude that it was an arson, couldn't it?
Hypothetically, yes, and we're talking about in the Willingham case. In the Willingham case.
And I'll give you an example. I recall a couple of years ago that when the governor's mansion burned down, there was a lot of people jumping in front of TV cameras speculating about what the cause of the fire was. It's always an interesting subject.
Nothing new in the world, yes.
And there was one individual who proclaimed himself to be an expert, who in great detail explained why it was an accidental fire. And on camera, continued to explain why that was an accidental fire. As it happens, that individual is the same person who has offered his opinions on the Willingham case. That would be Gerald Hurst. But his opinion, I guess, by now has changed because after he concluded all of that with all the information that he had, the security video from that was located, and it showed somebody with a Molotov cocktail throwing that into the building. Now, that kind of information, if you were in that individual's position, would probably change your opinion, wouldn't it?
It is always the case that when any of us write a report based on the information available now, And that's what you can work with. And if there are instances, I don't think it's the case in Willingham, but in other cases it may be, when new evidence comes to light, new evidence should be examined and opinions can change. And I don't think there's any investigator who wouldn't agree that give me new data, I'll reevaluate it, and I could change my mind. That's why we collect data, because it helps.
Well, and I suspect that's why you and other careful experts don't rashly proclaim that something was an accident when there's insufficient information to show that. And why your opinion today, and continues to be based on Dr. Kerrigan's question, continues to be undetermined. And perhaps Mr. Hirsch should have been more cautious and said undetermined as well, so that he had room to change it once the facts revealed that someone threw a Molotov cocktail. Well,
we can talk about, how useful it is to, make, rash proclamations of a cause of a fire. Obviously, what we do as a profession is work with the data we have, formulate findings, and those are potentially subject to change. Does that mean, because there might be new data later, mean we should refrain from making determinations? Well, I think not. But should we do it rashly? Of course not.
Well, and you've had some experience with that yourself here in Texas, haven't you? Wasn't there a case that went all the way to the Texas Supreme Court in which you acted as an expert and you testified? I don't know, you didn't testify. I think it was, you did this by affidavit, I think, which there was a summary judgment. And your opinion was that it was a fire that was caused by a halogen lamp in a room. And the other side obviously did not agree with that. And the Texas Supreme Court criticized you, I think, pretty seriously because the record, the evidence actually showed that there had never been a halogen lamp proved to be within the case. Therefore, it was unreasonable for you to be offering an opinion that a halogen lamp did that. And I'm not here to get into the details of that, but to point out...
I see that.
that looking back at people with a lack of information can be dangerous, can't it?
Yeah, there was data. There was information that indicated that there was a halogen lamp present.
We can disagree about that. The Texas Supreme Court wrote an opinion that disagreed with you. My point is, I like your opinion. I'm not quibbling with your opinion. I want to make it clear that your opinion is one of undetermined at a 20-year hindsight. And I'm assuming that you're not in great dispute. You have some details that you dispute. That these people did the job that they did, working as best they could with the standards as they existed at that time.
I think we'll differ on that.
Thank you.
Dr. Banger, I wanted to explore your recommendation of undetermined a little bit more. And let me throw in the way I look at it. I am a forensic pathologist, and I have a case. It's a lady that died of a drug overdose, and I can't decide if the drug levels by themselves are drug overdose or suicide. And therefore I call it undetermined.
Okay.
Versus a person on whom I do all the studies and there are no drugs, there's nothing there for me to pinpoint what the person died. I call it undetermined. So when you say undetermined, what precisely do you mean? Are you trying to tell us there is no evidence, or there is evidence but you can't decide if this is accidental or arson?
Typically, it's a multiplicity of hypotheses or causes that are consistent with the case facts and what we know about fire.
In this particular case, which sort of undetermined is you are tilting towards? Is it a case, in this Willingham case, whether there is no evidence to suggest anything, or there is evidence to suggest this could be accidental fire or could be arson? Is that what undetermined means?
Undetermined in this instance, I'll go with the Willingham case. On the stand, the investigators acknowledged that there were other potential causes that they could not eliminate.
Such as what?
The two that were brought up were a child fire setting, and the other was an intruder. And they said that they couldn't exclude those.
I think they said it was possible.
Well, that's what it means to not be able to exclude it. It's possible. That's what it means.
But what are the likelihoods of those two things actually being the explanations?
That is not part of the discipline of fire investigation in the 80s, and it isn't now.
But it might be something the jury could do.
We're not here. I'm not here to talk about what juries should do. Not something I'm here to talk about. I'm here to talk about fire investigation, and probabilities are not a part of the discipline.
The only two unexcluded causes that you're specifying are that a child did it and that an intruder came in and set a fire.
Those are the two that they acknowledged.
Well, they were asked specifically, is it possible? Is it completely possible for those things to occur?
They acknowledged that those were two possible causes, that they were possible. That meaning, in my parlance, cannot be excluded, cannot be eliminated.
But in their parlance, weren't they very clear though they thought that those two scenarios, given their understanding of all the facts, were extremely unlikely scenarios?
Fires are unlikely scenarios. It's unimportant whether they regarded them as highly unlikely or not. The discipline is elimination or not. That is, they are inconsistent with the case data, they are inconsistent with what we know about fire, or they're not. You could argue that we should be doing fire investigation on risk basis, probabilistic basis. Maybe that someday will be the way fire investigation is done. I doubt it, but that's never been the methodology of fire investigation. It's one of eliminating causes to come with a unique cause that's consistent with what we know. And imperfect knowledge at that.
Other than the defense attorney speculating that those two scenarios happened, did you find any evidence whatsoever in the case to support that an intruder came in and set that fire?
No, and I can see that we're trying to conflate what they were willing to acknowledge with what exists. I mean, the room of origin in the Willingham case was shoveled out the window, and the pile of debris was never examined. Well, how can you eliminate accidental causes if you're not going to even look at the remains of the contents of the room? It's not going to happen. I bring up what they acknowledge because, frankly, what they acknowledge is sufficient. The fact is that in their investigations, there were things that they didn't do that should have been done, which would, have allowed, determination of the efficacy of other potential hypotheses that they didn't even bother with. So it's, you have to eliminate all causes. Once they've admitted they haven't, we're done. Does that mean they did everything else right? No, it doesn't. But it also means that we don't need to focus on it either.
Thank you. Let me ask a clarifying question. You're talking about the two possibilities that they acknowledge. Is what you're saying, though, that those two possibilities, you have to assume a hypothetical that it was definitely arson or definitely a fire that was started by someone? You're just trying to figure out who that was when it started. Or are you including, there's other explanations besides human beings starting a fire. Is that accurate?
As a general principle, yes. Yeah, those were just two examples that came up in the context of testimony.
Did you feel like an electrical cause of the fire was ruled out in their investigation? Or did you feel like maybe they should have had an expert come in and look at the electrical system and see if there was any problem?
Yeah. Certainly the documentation of the electrical examination was poor. All you get is, I looked at the wiring and it was fine. And obviously no one can second guess you when that's all you do. And is that okay from an investigative point of view? No, that's not okay. When you shovel out a room and put it in a pile outside the window and don't examine it, how can you say that you've examined the electrical system? Because we have electricity in the walls for a reason, to power things in the room. And you didn't include in the electrical system, any of the electrical appliances in the room. So, I mean, how can you say that you eliminate all electrical causes when you didn't even look at them all?
So you spoke to them about that and confirmed that?
It was in the materials that you provided.
Did you speak to them?
Oh, no, I did not speak to any of the individual investigators. I did not think that appropriate under the circumstances.
What would be inappropriate about it?
It would be inconsistent with the charge that your commission provided me.
Did we ever tell you you couldn't speak to them?
I don't recall. I don't know that it came up.
Well, what I'm hearing earlier is that you say that in any legitimate investigation, the person is going to go out and talk to as many people as possible. What would be inappropriate about talking to the very people you are attempting to express an opinion about their work?
No, it wasn't what I was asked to do.
Well, you're the person who can tell us if you need to do it as an expert. Why didn't you ask us?
I think we can determine what we need from the record. I mean, I don't feel like I'm not able to make the determination that I made based on the record.
Well, wouldn't you have more confidence if you talked to the person who was actually there and did it?
But there is no downside to talking to those people. There's no downside
All right, thank you.
from an investigative point of view.
Right, that's all.
There are a couple of things that you were concerned with, and you raised that several times in your reports. One of them was that, according to the fire marshal, he had investigated something like 1,200 to 1,500 arson cases. The majority of them were arson. That really bothered you. Then there were a couple of other statements that nearly half the people in the fire died in a fire. And finally,
I'm sorry, what was the second one?
50% of people in a fire die. Mortality in a fire is 50%.
I don't know that to be correct, and I don't think I would have written it.
No. The fire marshal made the statement during the trial.
Gotcha.
The third thing is that he opined about the injury patterns, and he suggested that the injuries that Willingham had sustained could not have been accidental. So could you say?
Well, I think what he said was they were self-inflicted to confuse the investigators. That he self-inflicted injuries to make it appear that he had been, a mere victim.
So do fire marshals normally opine about injury patterns and suggest whether they're accidental or self-inflicted?
Are we talking now or then, or both?
Then and now.
Then and now, okay. Certainly, if you're doing a fire investigation now, an autopsy is something you will want to look at if there's a fatality. You will be interested in carboxyhemoglobins, you'll be interested in extent of burns, you'll be interested in, potential presence of alcohol, drugs, what have you. So from that point of view, using information that comes out of an autopsy, quite generally, utilized by fire investigators. Making judgments themselves about this guy couldn't have been exposed, didn't have smoke inhalation because, a number of days later he doesn't have trouble talking. That's out of bounds. I mean, that's just an individual guy making conclusions based on his own personal experience that isn't science at all.
I think given the number of people we have to talk today, we had set aside about an hour for each one, and we're well within that right now. I just wanted to give you an idea of where we're trying to pace this. So we've got about 10 minutes on Dr. Byler. Do you have other questions?
I have a question. Is it possible to determine accelerant use based entirely on a visual examination at a scene rather than chemical testing? And feel free to answer that within the context of the case information for Willingham.
Okay. Certainly at the current time, the presence of an accelerant is only establishable based on 921 or standard of care if a sample is taken and the determinant is made using analytical chemistry. That's it. Nothing else works. There are field techniques, there are sniffers, there's your nose, there's dogs, there's other things that are field methods. They are there to assist you in taking a sample so that the analytical chemist can do his work and it has a sample that's likely to, to be the appropriate sample to determine. But it's the analytical chemist that is the one who can make that determination ultimately. At the time, the determination that an accelerant was used was not that narrow. This is an area where I think there was an evolving standard that some people, the textbooks were at the point of saying, it'd be a really good idea if you did the analytical chemistry, but at the time I don't think they were saying you have to do it or else, or if the analytical chemistry comes back, no, it's not, I think that was something that was in flux.
And specifically, there was chemical testing in this case. Can you talk a little bit about the chemical testing that was done, not the methodology? I'm an analytical chemist for the record, so it's good to know I have a job. But, the type of testing that was done and the fact that there was, in fact, a positive finding and I believe some negative findings. Can you address that?
Right, we're doing Willingham again.
Willingham.
Yes. So in Willingham, I don't recall the number of samples that were taken. There was a positive for medium petroleum distillate, I believe, or kerosene, something of that nature, at an area at the front door. That was accepted by the investigators as indicative of the use of an accelerant. And my problem with that in this instance is that the front porch had material that was consistent with that and containers that were there and damaged. So it remained to be determined that it wasn't that material. Or clearly that material could be used by a person, as an accelerant, but that remains something. The analytical chemist doesn't tell you that. They tell you what it is.
But the chemical testing that was conducted on other items of evidence removed from other parts of the residence, presumably, was negative.
They were.
But that negative finding, I assume you would agree, is not a conclusion that there were no accelerants in the house. In other words, the accelerants can be burned up.
It is possible to have accelerants used and not find them.
That's all.
That is the case.
And doesn't it also depend on how quickly that evidence is collected? After all, when you're looking for accelerants, you're looking for volatile substances. And if the evidence has been in place for a while, essentially there can be nothing left.
Right, timeliness, methods, this business of, I guess, primarily in Willis, of washing the floors first. Help me. How can you possibly hope to find anything after that?
Dr. Byler, I just want to make sure I understand you well. What you are testifying today is that you are not saying that this is not an arson. What you're basically saying is that this is an undetermined cause of fire, and it is undetermined because there is insufficient evidence to show that this could have been due to natural causes or accidental fire. And this is because of investigative flaws. Is that what you're saying?
Well, there certainly are investigative flaws, but we can only make statements about the investigation that was done, right? And if you have a bad investigation, the likelihood of being able to sustain a single cause and exclusion of all others obviously goes down. The better the investigation is, the more likely you will be able to identify one and only one. But the investigator is entitled only to say this is an arson fire after he has gone through the process of eliminating all accidental causes. Having not done that, having acknowledged not doing that, he's not entitled or allowed to proclaim that this is an arson fire. That's an inappropriate professional action. When you have not eliminated the accidental causes or alternate causes, you professionally cannot say it's arson or it's whatever cause you might think it is. Because then it's just, at that point, it's just your personal feelings. And that's not what our profession is about.
But supposing he had excluded natural causes and accidental causes, could he then by exclusion call it arson, or he say let's approve arson?
The latter part, please?
I mean, just because you exclude natural causes or accidental causes of fire, does it automatically mean that this is an arson? Isn't it a burden on the investigator to prove that it is an arson?
Well, that is an area which has changed. I think that in the 80s, people did determine that it's arson because it wasn't accidental and it wasn't natural. Today, no. Today, with the scientific method, you have to show that your proposed cause, and you can't just say arson, it's got to be specific, is consistent with all the case data and is consistent with our knowledge of fire science uniquely, that it is consistent with what we know, everything we know, and everything else is inconsistent with what we know, then you're entitled. That has changed over time.
One thing that probably hasn't changed is ultimately when you offer a conclusion, wouldn't you agree that you are offering an opinion?
In the context of court, you are certainly offering an opinion.
And would you agree that two qualified experts looking at the same information can hypothetically come to opposite conclusions?
It happens.
And in fact, it happened in that case with you before the Texas Supreme Court. I don't recall who your expert on the other side was, but I'm assuming he had an opinion, an expert opinion, that contradicted yours, didn't it?
Well, it is normally the case in fire cases that when the experts on either side agree, those cases go away. And it is only the instances where that disagreement persists, or at least there's someone who persists in that, that the need for formal trials goes forward.
Right, because then someone, a fact finder, has to still evaluate the credibility of the two opinions and come to a conclusion about which one they find to be more reliable, don't they?
And in addition to the judge making his determinations as each keep a role.
Right. And that doesn't mean that one of those experts was negligent and the other one was not negligent, does it?
Simply that they disagree is not in and of itself, in the abstract, a determination of lack of conformance with the standard of care.
Right, and we're not.
If I can,
Go ahead.
follow up on that. There are judgments that are made. If you have an eyewitness and who says something, investigators make judgments about the quality of the information that they're receiving, and individuals can differ in their findings about what an eyewitness's testimony means.
Okay. And that's a real good example, because there is a lot of subjectivity to the credibility of that witness, to the detail that they provided, and one investigator may give something more weight than another investigator. And you would agree that even under the modern standard, there's a range within which different fire science experts can form different opinions.
That's true.
And so when the Supreme Court ruled against you in that case, they were not saying that you were incompetent. They were not saying that you were negligent. They were saying that these two experts had different opinions, and we judge this other expert to be correct in this particular case. Would that be a fair summary of that?
I'm not sure it's a fair summary of that instance, but it's a correct hypothetical that happens.
All right, thanks.
Dr. Myra, pertaining to this two experts differing in their opinion, how can you expect a liberal arts major, with probably a judge in a court, decide which testimony is better, which evidence is better, and which opinion is better? How can you expect a judge to decide that? Shouldn't there be another expert saying that instead of a judge?
Yes. In one of the documents that I recently provided you with, I spoke to that conundrum to some extent. judges are entitled to make use of their own experts, and almost never do. As you say, a liberal arts major, for the most part, not to say all judges are liberal arts majors, that's not true. But certainly, judges are asked to make judgments over remarkably broad areas of science, engineering, and other technologies, and they would be well served to make use of their ability to hire their own experts.
We've reached 10:30. I don't want to cut anybody off, but we can come back to Dr. Byler later on. Go ahead.
Question. You talked about a great deal in the report and in some of the other expert reports that we had access to about the lack of specificity with some of the visual indicators of patterns and things of that nature. In the Willis and Willingham cases, there was quite a bit of overlap in terms of those visual indicators, is that correct?
Yes.
Are there any differences that we should be aware of? Because clearly those cases have very different outcomes, but if I review the visual indicators and some of the sort of scene investigation from Willis, it's somewhat similar to Willingham. Correct me if I'm wrong. So can you elaborate on what those differences are and how that might have had such different outcomes? I mean, is there a scientific explanation for why that happened? Why they had such different outcomes?
No, I would not say that the different outcomes with regard to the judicial system are rooted in fire science.
So the indicators in those two cases, the observations that were made by the fire investigators are quite similar.
Yeah, they're relying on these floor patterns as indicating use of massive amounts of accelerant that's not well founded in fire science. I will offer up, because you opened the door to it, there are certainly differences between these two cases. Some specifics are very much the same, some are somewhat different. I personally don't see how one could make the determination that one met the standard of care and the other one didn't. They're sufficiently similar in the mistakes that they made that I don't personally see how one could make a differentiation between the two in that regard.
Thank you very much, Dr.
Thank you.
Next year from John DeHaan. Mr. DeHaan was obviously not one of the people who was early on assigned to do part of the investigation like Dr. Byler, but he is a recognized fire science expert and provided very helpful information. I frankly found your documents of all of these the easiest to read and understand, and I compliment you on that. I also thought that they, for the first time, offered some opinions that found a great deal of consensus with commission members. So I think that's largely why we're here, is for us to follow up on some of that. Do you have any short opening remarks?
Thank you very much for the invitation to participate. Just by way of introduction, you've seen my CV, and it was outlined in my original report. But just as a reminder, I'm a criminalist by experience. I spent up to now over 41 years in forensic laboratories or independent forensic practice. My original degree was in physics, and so when I did get involved in fire investigation and fire science, the processes involved, of course, fell readily within my pre-existing educational preparation. I got involved originally analyzing fire debris for the county crime lab, and the puzzles started shortly thereafter when I got unusual, or what I considered interesting, laboratory results, and I turned to the expert, the scene investigator. I said, well, where did this come from? Why do I see this? And they didn't know. Well, as a scientist, if somebody says, I don't know, the usual reaction is, well, let's find out. And I was lucky enough in 1974 when I went to work for the state of California that my position was actually partially funded by the then state fire marshal. And one of my duties was helping present live burn training exercises for state and local investigators. And my first day for Department of Justice was spent making Molotov cocktails and observing them being thrown. People have made the comment since that I claim that I've observed or caused to have started something on the order of 500 or 600 structure fires. People point out that I must have had a very interesting childhood. I point out in contrast that while I grew up in Chicago, I did not grow up in the neighborhood where the fire started. I was a physics experimenter. I never set fire to anything until, well, intentionally, until the state of California asked me to. But that was an unusual turning point, I guess, in that I got a chance to see real fires in real structures set by a variety of techniques, and observe them, photograph them, videograph them. And it was apparent after the first few years that much of what I was seeing and my fellow investigators were seeing in these fires wasn't what the books were saying. The books, as several people have pointed out, that were the basis of investigator training in the 80s, was very limited. And virtually all of them were written by scene investigators from the insurance or police or firefighting backgrounds. The only one...
One of the points that we noticed when you were talking about that in your written materials was you seemed to have a really good grasp and gave us a very good summary of this particular development, which was important to us because we have struggled with the notion of whether or not you can judge someone's work at a time against a standard of practice if a true standard of practice didn't exist. And I'm going to summarize it, but you tell me if it's accurate or not. It seemed to me that you came to the firm conclusion that at the time of the Willingham investigation, there was in fact not a standard of practice that you could measure against people's work.
Not a uniform standard of practice. That's correct.
Well, and I notice you add the word uniform, but isn't that sort of the point of a standard of practice, that it is uniform across either a community or a state or a nation?
Well, that's one of the critical issues with fire investigation is that fire investigations are I've described it flippantly, but somewhat accurately, is when somebody says, well, who does fire investigations? I said, well, everybody and their dog. And that, unfortunately, is true, because fire investigations...
Is or was?
Well, it still is, yes. It is and was the situation. Where fire departments are, under most fire codes, are charged with establishing origin cause of fires. If there is a suspicion that the fire was deliberately started, then police authorities are involved. Sometimes that's in the same person as a fire marshal, or police detectives or somebody from another law enforcement agency that has law enforcement powers of evidence seizure and interviews and filing criminal charges and things like that. In some cases, it's entirely done by fire marshals from start to finish, but fire investigation across the United States is the ugly stepchild. Nobody really wants to do it. The fire departments don't want to be bothered because it's not very exciting, it's time consuming, and they don't often see it as helping in their major responsibility of protecting their community, although if they stopped more of the accidental and intentional fires in their communities, they would be saving money and lives and property. But police don't want to do it because the scene is ugly and messed up, and there's been hoses and people and destruction. It involves kinds of evidence that most police investigators don't want to deal with. The forensic scientists are not often involved, except, at least in my experience, when there's been a fatality. And as a criminalist, that's usually where I got called. We have a fire, yeah, we have a body. Oh, and...
Jump back to my question.
Sure.
Which is, was it your conclusion that there was not a standard of practice back at the time of the investigation of the Willingham case for us to measure against?
Well, and I come back to my response that there was not a uniform one. There were within agencies guidelines for how this was supposed to be done. There was a body of knowledge, faulty.
Let me rephrase it then, because at the time we initiated this investigation, we weren't even using the word standard of practice. We didn't have a definition of negligence. We didn't have a definition of misconduct. We have since adopted one that focuses upon the standard of practice that existed at the time of the investigation. It's part of what we asked Dr. Byler, and I guess the commission will continue to explore this, but assuming that we're talking about a standard of practice for Texas, in other words, statewide, everyone held to the same standard for how you conduct a fire investigation, was there a uniform standard of practice in Texas against which we could measure it against for the Willingham case in 1991?
With the with the exceptions of the general investigative principles that Dr. Byler mentioned a few minutes ago, interviews and evaluation of all possible causes of fire, to my knowledge, there was not. I did cases in Texas. I was with ATF for 4 years. I conducted investigations, or I assisted in investigations here in Texas, and starting about 1990, I did outside cases here in Texas. So I've worked with Texas authorities on a variety of cases. And just like everywhere else, the practices have evolved over the past 25 years.
Okay, thank you. That repeats what your conclusions were in your written report to us. Any questions from the commissioners? Thank you very much.
I'm going to ask you.
I'm waiting for somebody to raise their hand.
A little slow.
You're sorry. Dr. Eric, you want to start?
Go ahead.
Would it be your opinion, would you concur with Dr. Byler, based on your review of the documents, that the cause of the fire, based on standards, and I'm not going to use the term standard of practice because I